What are taxes? To get an extensive definition of the term taxes, one may look at the treatise on the law of taxation put forth by Thomas McIntyre Cooley, where he defines taxes as, quote, taxes are the enforced proportional contributions from persons and property levied by the state by virtue of its sovereign support for the support of government and for all public needs. The state demands and receives them from the subjects of taxation within its jurisdiction, that it may be enabled to carry into effect its mandates and perform its manifold functions. And the citizen pays from his property the portion demanded, in order that, by means thereof, he may be secured in the enjoyment of the benefits of organized society. The justification of the demand is therefore found in the reciprocal duties of protection and support between the state and those who are subject to its authority, and the exclusive sovereignty and jurisdiction of the state over all persons and property within its limits for governmental purposes. The person upon whom the demand is made, or whose property is taken, owes to the state a duty to do what shall be his just proportion towards the support of government, and the state is supposed to make adequate and full compensation in the protection which it gives to his life, liberty, and property, and in the increase of the value of his possessions, by the use to which the money contributed is applied. Taxes are supposed to be regular and orderly, and they are commonly required to be paid at regular periods. In English law, they have sometimes been demanded under the name of subsidy, this being a special tax levied for some exceptional occasion or need. The term is scarcely known in American law. Taxes differ from forced contributions, loans, and benevolences of arbitrary and tyrannical periods, in that they are levied by authority of law, and by some rule of proportion which is intended to ensure uniformity of contribution and a just apportionment of the burdens of government. In an exercise of the power to tax, the purpose always is that a common burden shall be sustained by common contributions, regulated by some fixed general rule, and apportioned by the law according to some uniform ratio of equality. The power is not therefore arbitrary, but rests upon fixed principles of justice, which have to for their object the protection of the taxpayer against exceptional and invidious exactions, and it is to have effect through established rules operating impartially. The apparent equity of any particular exaction cannot support it as a tax unless it is made in accordance with law. Nor, on the other hand, can the seeming injustice of a levy actually authorized by law defeat it, provided it is made under such general rules as the wisdom of the legislature has determined are needful and proper for the general good. The impossibility that government should be administered even by the most conscientious rulers without unjust consequences in particular cases is universally recognized, and the state is therefore considered to have performed its full duty when it has devised and established such general rules and regulations as seem calculated to reduce such consequences to a minimum. Particular names are applied to some kinds of taxes, whereby they are commonly known and distinguished from all others. But in nearly every case the term is not used with such precision, and its use may therefore be liable to cause confusion. Thus, the word duty is sometimes used in a general sense as synonymous with tax. but in common use it means an indirect tax imposed on the importation, exportation, or consumption of goods. The term impost also, in its general sense, signifies any tax, tribute, or duty, but it is seldom applied to any but the indirect taxes. Customs duties, as the term is commonly used, are the duties levied upon imports and exports, while excise duties are inland imposts levied upon articles of manufacture and sale, upon licenses to pursue certain trades or deal in certain commodities, upon special privileges, etc. The term toll, in its application to the law of taxation, is nearly obsolete. It was formerly applied to duties on imports and exports, but tolls, as now understood, are confined almost exclusively to charges for permission to pass over a bridge, road, or ferry owned by the party imposing them.